Hi, I'm Attorney Tom Lamb. Today I'd like to take up this issue with you. Should U.S. patients be prohibited from filing lawsuits against medical device manufacturers and pharmaceutical companies for injuries caused by their products? First of all, I presume most of you believe, because as Americans we have always looked to our court system to vindicate our rights, that patients are allowed to file these lawsuits today. With regard to most cases against medical device companies, however, as of February 2008, you were wrong, and soon injured patients may be prohibited from getting legal compensation from a pharmaceutical company for serious side effects caused by a prescription drug. On February 20, in the Regal versus Medtronic case, the U.S. Supreme Court granted legal immunity to manufacturers of medical devices which had been approved by the FDA. This means that in the future, for most instances, the medical device manufacturers will have no financial accountability for their mistakes if and when their products harm a patient. To reach this decision, the Supreme Court used the legal doctrine of federal preemption. Ironically, this doctrine comes from our Founding Fathers' Constitution, but in recent years it has been used by the current Bush administration to abolish a person's right to sue when injured by a company's product. As a start, let us focus on the FDA approval part of the Supreme Court's Regal decision. During this past year, the Institute of Medicine, the Government Accountability Office, and FDA's own Science Board have all issued reports that essentially reach the same conclusion, and that is the FDA is largely incapable of protecting the public from unsafe medical devices and drugs. Moreover, the FDA does not do its own testing. Rather, the FDA is almost totally dependent on the companies that it is supposed to oversee to provide the agency with data concerning the safety and effectiveness of new prescription drugs and medical devices. Further, the vast majority of FDA approvals occur without there being any representation of patients' interest, and safety decisions after the drug or device is approved rarely include input from patient advocacy groups. Meanwhile, the medical device manufacturers and the pharmaceutical companies clearly have an inherent conflict of interest when addressing safety issues concerning their products, which are, after all, intended to make them a profit. In addition, these business corporations have stronger legal obligations to their stockholders than they do to the patients who use their products. Let's return to the question at hand. Should patients have access to our court systems to sue for injuries? In October of this year, 2008, the Supreme Court will hear oral arguments in the Wyeth v. Levine case. The primary issue in that case is whether people who suffered a drug injury should be able to get any legal compensation from the pharmaceutical company responsible for that drug. You will probably be surprised to learn that at this hearing, the drug company's lawyers will be assisted by the Bush administration's Solicitor General in making their argument that an injured patient should not have any legal right to compensation. In more detail, the drug company Wyeth and the Bush administration will be arguing in this Levine case that the Food, Drug, and Cosmetic Act of 1938, under which the FDA regulates prescription drugs, has implied preemption due to the structure of this statute. That is, the law's actual text does not include any preemption clause. The Levine case involved a Vermont woman who lost a hand and forearm to gangrene after being improperly injected with the drug Phenergan. At the trial of this lawsuit, Wyeth argued that its drug had met FDA's federal labeling requirements, and therefore the drug company should not have any legal liability under state law for this patient's injury. The trial court judge disagreed with Wyeth on this issue and the jury in that case went on to award $6.8 million in legal compensation to Mrs. Levine for her injury. The Vermont Supreme Court ultimately upheld the judge's ruling and the jury verdict, but the United States Supreme Court later accepted this case for review upon the request of the drug company and the Bush administration. As I said, oral arguments regarding the federal preemption issue will be made to the Supreme Court justices in the Levine case later this year, in October 2008. Sometime thereafter, and no later than the summer of 2009, our Supreme Court will decide whether the FDA approval of a prescription drug will serve as a prohibition against patients filing their personal injury and wrongful death lawsuits against drug companies. According to some critics, the prohibition of drug injury lawsuits by operation of the federal preemption doctrine may have some merit in an ideal world where the FDA was performing its drug safety regulatory functions at 100%. But that has not been the situation in the past, nor is it the case today. It is my opinion that the U.S. Congress should move quickly to pass legislation that would correct the legal decision by the Supreme Court and serve to prevent such a ruling against patients' rights in the Levine case. This legislation is needed because, in my experience, the possibility of becoming involved in product liability litigation is a significant incentive for the medical device manufacturers and the pharmaceutical companies to ensure that their products are safe for use by American patients.